100 years since a white mob in Tulsa stormed into the Greenwood district, better known as Black Wall Street, and massacred hundreds of Black Americans. In a matter of hours, 35 blocks of the vibrant community was burned to the ground and thousands of homes and businesses were destroyed. Viola Fletcher, one of 3 remaining Tulsa survivors, was 7 years old when her parents woke her up telling her they needed to flee their home. Earlier this week, Fletcher, now 107 years old, recalled before Congress just how much that night forever changed her.
I still see Black men being shot, Black bodies lying in the street. I still smell smoke and see fire. I still see Black businesses being burned. I still hear airplanes flying overhead. I hear the screams. I have lived through the massacre every day. Our country may forget this history, but I cannot.
On Tuesday, President Biden gave what many considered a powerful speech commemorating 100 years since the 1921 Tulsa Race Massacre. But what he didn't do was commit to providing any sort of reparations for the victims or survivors of the massacre. My next guest says in a new op-ed for the Washington Post that merely acknowledging the massacre isn't enough. There must be legal culpability for the perpetrators of the violence and devastation. Suzette Malveaux is provost professor of law at the University of Colorado Law School. Suzette, so glad to have you on tonight.
Hi, thank you. It's a pleasure being here.
Okay, so you served for 6 years as pro bono counsel to Tulsa massacre survivors in a federal lawsuit against the city of Tulsa. How did you get involved with the case?
So thank you for asking that. This was literally 20 years ago. As you may know, I mean, people are familiar now with the devastation and how difficult and traumatizing this massacre was. But this was covered up for a long period of time by the city of Tulsa, the state of Oklahoma, the right media. There was no information that was available about the extent to which the government had participated in one of the worst race massacres in the country. And so, at the time, you couldn't find it in textbooks in Oklahoma. The government had destroyed evidence and hid evidence. So it wasn't until 80 years later, in 2001, when a report came out. There was a commission, a bipartisan commission, that did a 4-year investigation. And they had historians and legal scholars and lawyers and archaeologists and experts from all over the country comb archives and libraries, interview hundreds of survivors and witnesses. And when they did this, they came to the conclusion, they found out that the city of Tulsa, the state of Oklahoma, had armed, had authorized, and commanded a white mob, in fact, to destroy the city of Greenwood. So that information came out in 2001, 80 years later. When we learned of that, a team of, really I can't say it any differently, but sort of a dream team of lawyers and legal scholars and community folks got together and decided that they were going to bring a lawsuit because for the very first time, we had the evidence to show that the government had violated the constitutional rights of the survivors of the Tulsa Race Massacre. So at that time, we represented 130 survivors. Of course, most of them have died, and we're now down to 3 known survivors of that massacre. And as a baby lawyer, I had the privilege and honor to participate in litigation with, as I mentioned, a team of just brilliant people like Professor Charles Ogletree from Harvard, a law professor from Harvard, Johnny Cochran, the renowned historian John Hope Franklin, Eddie Faye Gates from Tulsa. I mean, just people from all over the country that got together and brainstormed and thought about how do we do this. So we filed 2 years to the date after that report came out, alleging constitutional violations in federal court by the government itself.
What was it like working with clients who bore witness to such a terrible part of our nation's history that many ignore or are ignorant of?
It was truly a treasure and an honor to represent them. It was probably the most meaningful case that I ever had as a young civil rights lawyer. I was a lawyer, and then I turned to a law professor, and it was the only case that I actually took with me, because it meant so much. I absolutely loved my clients, and we this is a we had a lot of fun, and we worked really hard, and we felt incredibly dedicated to them to do the right thing. I think the most important thing for us was to make sure that they knew that their voices were being heard, that they mattered, that somebody cared, and that we were going to fight for them till the end. So we had to we kind of did everything. I mean, we had to engage in some pretty creative maneuvering, because in the federal court system, when we filed our case, the case was dismissed because of the statute of limitations, the filing deadline, and the court said that we had 2 years. Right? Somehow survivors, in the middle of one of the worst racial massacres in the country, were supposed to kind of get it together within 2 years and file 2 years after that devastation. So that was the
Yeah.
2 year statute of limitations. The court said, all right, we recognize the extraordinary circumstances that people were, this was a cover up. They didn't have that information. They were traumatized by what had happened. So we'll give you, let's say, to the 1960s, when Jim Crow segregation was sort of technically over. You had new civil rights statutes on the books. Supreme Court had rejected the separate but equal doctrine. So we think it was reasonable for your clients to have filed then. And so we pushed back on that, and we argued no. As we know, just because the black only or white only signs come down, it doesn't mean that the terror of the trauma does not continue to exist. We heard from Mother Fletcher a couple weeks ago before Congress that, in fact, that's not the case. And we know that the cover-up was so extensive that nobody really knew the extent to which the government participated until that 2001 report. So we argued that, justice is timeless. We deserve to have our clients be heard on the merits. We appealed that court decision. The appellate court denied relief. We then petitioned to the Supreme Court. It denied a hearing. So then we decided, well, we'll go to the international courts. And so we went to the international courts, and we made the argument that the American courts were not giving access to American citizens for human rights violations. When that didn't work, we ultimately went to Congress. And when we got to Congress, we drafted some legislation saying we would like the statute of limitations to be told. We just want 5 years. Give us 5 years so that we can have our clients heard on the merits. That was not successful. And so, I wrote a law review article. I'm a law professor now, so I didn't know what else to do. I wrote an article about why it was that when you're talking about cases of government-sanctioned racial violence against American citizens, that there should be no statute of limitations, right? That for equitable reasons. And I know as a lawyer, there are exceptions made to statute of limitations for all the time for reasons of justice and equity. So anyway, that article was entered into the congressional record in support of our legislation. That didn't work, so we ended up basically taking our case across the country and just trying to educate people about what happened and making sure that people learned about that massacre and the work that needed to be done.
Well, Suzette, you mentioned justice is timeless, and that's something you reminded us all of at the end of your article. What does justice look like for the victims and survivors, and are you hopeful that it could still be achieved?
So I think there are a lot of great proposals and ideas in terms of what that could look like. And so I think it's what I would say. I know we never got to the point where we actually were able to seek relief or a remedy because we were thrown out of court very early on because of the deadline. But I think that we need to really listen hard and ask that question to the survivors and the descendants themselves. I feel like they have the answers. There are a ton of things that we can do. I think it's a matter of political will, right? I do think that lawmakers can tomorrow, they don't have to have a statute of limitations. So they have the power to eliminate that. We know Congress has that power. We know that the courts have the power to exercise discretion if there are statute of limitations for equitable reasons or justice, and to give the survivors and their descendants the give them the agency, right, that they deserve. They get to decide, what does that look like? Does it look like a scholarship fund? Does it look like health care? Does it look like investing back into the community? Does it look like restitution? And so they need to be the primary leaders and beneficiaries of whatever efforts are made going forward. And I'm hopeful and I'm excited about the new litigation. Some of the very lawyers that I worked with 20 years ago are part of that new lawsuit. And they're looking at some new claims, state law claims that deal with unjust enrichment, and public nuisance claims, things where you don't have the same kind of statute of limitations problem. So, and there's new legislation that's being proposed. So I think it's time. I think people are really hungry for doing the right thing, and 100 years later, it's time.
It is time. Provost Professor of Law at the University of Colorado Law School, Suzette Malveaux, it was a pleasure. Thank you for coming on tonight.
Thank you. Thank you. I appreciate it.